SJC-12012, Commonwealth v. Eric S. French.
Good morning, Mr. Vazone.
Yes, good morning, Chief Justice Gantz. If it pleases the court, my name is Joseph Vazone. I represent the appellant Eric French in the appeal that's before this court today. Our position on this case, as evidenced in what we wrote in our brief, is that a single fingerprint on a plexiglass window that was removed from the frame of a store without more is insufficient under the Lattimore standard to convict my client of breaking and entering into that store. The majority, however, obviously disagreed with my assessment, and that's what brings me before the court today. I would take a look at the appellate decision of the appeals court, and the part that I had some difficulty with was where the court seems to suggest that there was circumstantial evidence above and beyond the single fingerprint, which, when taken in conjunction with the single fingerprint, gets us over the hurdle of guilt beyond a reasonable doubt.
Mr. Vazone,
Yes.
The photographs that were reproduced, and no fault of anybody's, and we'll get the originals, are a little blurry. And I think
They are.
I think the location is critical in this case. Could you explain to me where the window was in relation to the door entranceway and the like?
Well, if the door was right here, where the front of the podium is, then the window would have been sort of like almost at a 35 or 40 degree angle like this, and another window would have been like that, and then there would be windows over here. So the window is right next to the entranceway of the market.
Is it like a bay?
Kind of like, yes, Justice Botsford.
Coming out?
Just like this. The one window would be here, the other window would be here, the entrance to the store would be here, and then the knee wall, we call it a knee wall because it's about the height of one's knee, is what the window rested on.
And then the fingerprint was up high or no?
Well, that's debatable.
It seems confusing to me from the record.
If the window was in the frame, then you could say with certainty where the fingerprint was found. But the window was not in the frame when the police officers came to the scene. The window was out of the frame, and it was resting up against the entrance door of the market. And it was there for 13 hours. So once you remove that window from the frame and you leave it there for 13 hours, how can you say beyond a reasonable doubt that the fingerprint of my client was impressed upon that window at the time of the commission of the crime beyond a reasonable doubt?
Well, to a Lattimore standard.
Well, correct. But, you know, the part that I take issue with in the majority opinion, it says, in addition to the fingerprint, the circumstantial evidence depicts a crime scene that essentially speaks to how the burglar gained access to the market by entry through a window, I agree with that, from which a pane had been removed, with a milk crate that it could have been used to bolster the burglar into the market from the ground. I don't have a disagreement with that. But then it says, as in Commonwealth versus Yee, here the defendant was unknown to the victim of the crime and had no apparent connection to the store. Well, I don't think Yee is really a good case to use to support their contention that there is sufficient circumstantial evidence in this case. Yee involved a private residence, and there was a fingerprint found on a piece of furniture that was found in the basement of that private residence, and Mr. Yee had never been in that residence, didn't know the owner, was a subsequent owner. They thought the previous owner, who was a restaurateur, owned the building, and that's why they broke into it. They thought there'd be a substantial amount of cash there, but unbeknownst to them, the house was sold to someone else. So there's no connection. It's a private residence. In this case, we're dealing with a grocery store. Everybody has a connection to any grocery store. If you go in it, it's open to the public. And moreover, in our case, the defendant lived in a shelter on Worthington Street And according to the testimony of the police officers and the arguments made by the prosecutors at the time of the trial, was within walking distance of this grocery store. So how this individual could have no connection, okay? I don't see how the court could have made that conclusion.
So I take it what you're saying is, given the 13 hour, I mean, it's not so much that, I mean, it seems to me if the window were in the frame and the fingerprint is like over, I think it says over 6 feet above the ground?
5 feet 8 inches to 6 feet, Judge, above the ground level.
And how tall was your client?
He's about 5'10", 5'11". He's taller than I am. I mean, I'm not that tall, but as I said in the appellate court, if you walk up to a window, a lot of people, what they do is if they want to look inside the store to see they'll do this.
Yeah.
Okay, they'll put their hands like this. Now, the court will accept my height as 5'7" with shoes on. Look where my hands are. That's 6 feet, easily. And my client, when I went to visit him at the jail, was taller than I was. I mean, he wasn't a basketball player, but he was taller than I was. So it's easily, even when the window is in the frame, you can easily put your hand at a level of up to 6 feet.
And without that, I take it you'd say, hey, it's there 13 hours, he lives very close, he could have walked by, after it was already out. I mean, you don't, could you?
Well, absolutely. That's what I think that the majority down below didn't really put a lot of weight on. That it was out of the frame. I mean, if the window was still in the frame, then I probably wouldn't be here, quite frankly. But when the window's out of the frame and there's no other evidence, there was no fingerprints taken on the inside of the building, there was nothing at all within the interior of that building to suggest that my client was in there, for an illegal reason. So when you take all of that evidence together, I think I would strongly agree with the dissenting opinion of Justice Agnes that there's just isn't any there. That all you have is a single fingerprint on the side of a window, and the question is, what is a side? I mean, if this is the window, is this the side? I don't think you could, I mean, if this is the thickness of a pane of glass, the thickness of this brief, which isn't that thick, could you put your fingerprint on there and lift it? I don't think so. Okay, if he pulled the glass out of the window like this, then his ring finger would be on the back of the glass.
So what's the testimony about where it is on the pane of glass? Was it clearly on the exterior of what was the exterior of the glass?
Well, again, because the window was removed from the frame, okay, by the burglar, whoever that individual was, we don't know what is exterior and what is interior.
But what did the police officer say about the location of the fingerprint?
He said it was on the edge of the window. I mean, the testimony is somewhat nebulous on this point.
Does he say it was sort of like where you would do it if you were lifting it or something like that?
Well, that was his opinion, if you were lifting it. And again, the window was out of the frame, and he said it was on the top side of the window. Well, yeah, it was on the top side of the window. Who says that the top was the top? Once you remove a window from the frame...
Can't you usually tell that, which is the top and the bottom?
Well, if you put it down like this, if this comes out of the frame, this is the top. But if you would put it on like this, now the top becomes the bottom. We don't know how it was put on the ground. He could have propped it up. Thing could have fallen over. He picked it back up and put it back up on up against the. We just don't know. And being there for 13 hours to say beyond a reasonable doubt that the fingerprint was impressed upon that window at the time of the commission of the crime, without anything more, is, quite frankly, is far-fetched.
And was there evidence as to what tool was used to remove the window?
Nobody knows. Nobody knows. It was just removed from the frame. I mean, I would think that if you're going to remove a window from a frame, you would need a hammer and a screwdriver or something to remove the molding around the window. But that never came into evidence. There was no testimony as to how it would have been pure speculation anyway, because by the time that they got to the store, some 13 hours later, all there was a window and a knee wall. And the other thing too is about the milk crate. They tried to put significant emphasis on the milk crate. Well, again, we're talking about a knee wall, which is about as high as one's knee, which is 2 feet. You don't need a milk crate to get over a brick knee wall. You just step over it and go in the store and do what you got to do. So, and the other thing too is it's not that stretch of imagination to think that you would find a milk carton in front of a grocery store. I mean, that's usually where you find them. So for all of those reasons, Your Honors, I do not believe that there was any circumstantial evidence to corroborate the evidence of that single fingerprint to prove beyond a reasonable doubt that the fingerprint was impressed on that window at the time of the commission of the crime, and therefore the evidence against my client was insufficient to establish his guilt. And I believe the majority's decision should be reversed for those reasons. If no other questions, I thank you very
I
much.
have a question for you.
Yes.
So doesn't the prosecution only have to reasonably exclude the hypothesis that the prints were made at a time other than the crime? Just reasonably exclude that?
Well, yes, but they can't reasonably exclude it because you have a window that's out of the frame for 13 hours. That to me is everything. If the window was still in the frame, okay, and judging, then you would know exactly where the fingerprint was. You could say with certainty, well, it's at the top of the window, it's at the side of the window because it's still in the frame. Once you remove that window from the frame, all bets are off as to what is the top and what is the bottom. It's basically, as you see in the exhibit, it's a rectangular piece of plexiglass. And how it was oriented in that window frame is just pure conjecture.
Okay, thank you.
Thank you very much.
Ms. Urlato, good morning.
Good morning. May it please the court, my name is Allison Urlano and I represent the Commonwealth. I'd ask that you affirm the defendant's conviction. Sufficient evidence was presented in this case to prove that the defendant was the one who broke into Albano's Market and left his print behind during the commission of that crime. The Commonwealth is permitted to proceed on fingerprint evidence as long as the Commonwealth couples that with other circumstances that reasonably exclude the hypothesis that that fingerprint could have been left at a time other than during the commission of the crime. And that's exactly what the Commonwealth did here. The other circumstances that were presented, were that the location of this print was found high up on the glass. The testimony came in that it was approximately 6 feet above ground level.
Can you tell from the, and I don't know this from looking at anything, can you tell from the window which is definitely the bottom and which is the top? I mean, Mr. Fazzone's argument is, well, yeah, it's up there when you have it one way, but it could be down there if you turned it around.
Your Honor, I think that the testimony was clear. The detective testified, actually on redirect examination, that he could tell where the print was located as the window was, while it would have been in the frame. So this was actually talked about throughout the detective's testimony. It was page 41 to 42 of the transcript. The prosecutor did try to clear that up, and it sounds like the detective, when he arrived, made note of what the plexiglass looked like, what the frame looked like, and that in his opinion, he could tell the way that the plexiglass would have been oriented in that frame, that the print was in fact high off the ground, is how the detective testified. In addition, the milk crate corroborates that theory. The milk crate was there, and the officer did surmise that that milk crate was used in order to help the burglar get up that high.
The milk crate's on the sidewalk?
It was right in front of the door in the photograph. And again, the testimony was that this was an alcove. I believe that's the word that was used. So essentially,
wasn't that where the plexiglass was put, right in front of the door, or am I wrong about that? So where was the milk crate in relationship to the plexiglass?
I believe it was on its side, right near the front door, as well as the plexiglass.
Got it.
As you can see, the door is essentially set back with 2 windows around the side.
Do you have any more information about where the actual prints were, if they were on the edge or on the front or the side of the window or the glass?
The testimony that came in was around the sides, like if you lifted it and put it to the side like that. Clearly, there was some type of demonstration done as well. The judge referred to such a demonstration in his findings. We don't have more information about that. But the testimony itself is very clear that it was on the sides as if you lifted it out of the frame and put it down. And I think that's very clear that it was not just on the front of the window. I think as my brother said, putting your hands up like this to lift it in, but common sense says you can't really lift a window out of the frame. And the testimony was it was in a location as if it was being taken out of that frame. So I would argue that it's clear that it was on the side, and the side of the window is not an area that is accessible to passerby, to shoppers.
Was there evidence of damage of the door, of the window frame?
I don't believe that there was testimony about damage to the frame itself. I don't remember that coming out, no. But again, the fact that this was found on the sides reasonably excludes any hypothesis that that fingerprint was impressed by a random shopper, a random passerby. That especially combined with the fact that it was so high up off the ground.
Well, it wasn't so high up off the ground when it was resting against the door.
No, and it was not. And the fact that it was resting on the ground,
Well, resting against the door, it's sort of at an angle. It's not that high up, I don't think. It's not that, I mean, this looks sort of like a handle of the door.
correct, Your Honor. There was a period of time that that plexiglass was out of its frame before the police arrived and before the shop owner was notified. However, the Commonwealth does not have the burden to exclude every hypothesis of innocence that might come forward. The Commonwealth's burden is to show, looking at the record in its entirety, the elements of the crime beyond a reasonable doubt. And I think what's important is that it's for the judge, the fact finder, to interpret any conflicting interpretations of the evidence. And so Justice Agnes, in his dissent, certainly wrote about the possibility that the defendant could have come and touched this window as it was out of its frame and resting. However, I would argue that that's not a reasonable hypothesis. The testimony was that it was out of its frame overnight when the store was closed, and that, I think importantly, the location of this fingerprint, we would have to assume that the defendant walked by this store in the middle of the night, went into the alcove, even though the store was closed.
The owner left at 6 p.m. That's not, I mean, there's a long time before it's the middle of the night.
Correct. We don't know exactly when she said she came back, I believe, at night and noticed that the window had been.
Is that the 13-hour time period that your brother mentioned?
Yes, there was that period before the police were notified.
So that would have gone from what, like she came about 5 o'clock in the morning?
It's unclear exactly.
So that 13 hours would have put it someplace around 6 o'clock.
I believe the police came around 7:30 in the morning.
Yeah,
The
because
police came.
13 hours would be 7,
Right,
from 6 to 7.
right. But what's important here, no matter how long it was out, is that the store was closed, so we would have to assume that the defendant walked into this alcove while the store was closed and touched this window essentially in the exact same location that the burglar would have had to touch it in order to get the window out of the frame.
That you had to touch it there to get it out of the frame.
Well, because the testimony was that
We know there's a fingerprint on it, but we don't know when the fingerprint was put there. It doesn't have to be where the window was taken out of the frame.
well, what the Commonwealth needs to do is reasonably exclude the hypothesis that it was placed there at a time other than during the commission of the crime. And certainly, that is an interpretation of the evidence, that it could have been touched at that time. But all the Commonwealth has to do is reasonably exclude that hypothesis. The Commonwealth is
Yes,
not...
but I thought I understood you to say that the fingerprint had to have been put at that location during the removal of the window, and I'm just saying that we don't really know where somebody would have had to have touched it in order to take it out. We don't even know how it was taken out of the frame.
That's correct. My argument is that the evidence supports that it was picked up out of the window and placed to the side, and that's where that fingerprint was located. That's what the evidence does support, and that's what the judge found. And the judge was very careful in his thought process. He certainly considered different interpretations of this evidence. He asked the witnesses questions himself. He reminded the prosecutor that it was the Commonwealth's burden to disprove that it could have been placed at a time other than during the commission of the crime. He even stopped the prosecutor during his closing argument and ask questions about when it could have been placed.
What you're saying, I think, if I understand it, is there has to be circumstantial evidence beyond just the fingerprint, and that considering all the circumstances and the location of where the print is, you can draw a reasonable inference that that print was left when the window was in place.
Correct, and that the Commonwealth has reasonably excluded the hypothesis that it was not placed during the commission of the crime. And I think it's important to remember that the test is whether the evidence permits a finding of guilt, not whether it requires a finding of guilt. And again, it's not the Commonwealth's burden to exclude every conceivable alternate hypothesis. It's simply enough to show beyond a reasonable doubt looking at the record as a whole. And I would argue the Baxter B case, which is an unpublished decision, but which I did attach in my appendix, is instructive in this area, because in that case it was a residential home. However, it was a street side window, and really there was not much more than the location of the prints on that window being the point of entry for the break. And the court addressed the fact that the defendant could have hypothetically left the fingerprints at a prior time. The court said that.
Well, that was a lot stronger case, though. You have fingerprints there, and then in that case, the defendant's saying, I was never there.
In the Baxter B case, yes, that's correct.
So that's a lot stronger than this case.
Well, I think it's different. I think we also, though, in this case, there's circumstances that weren't present in the Baxter B case. I see that my time has
Now,
expired.
but one question. You mentioned the alcove. This
Yes.
was, I'm trying to figure out from the photos, page 9 of your brother's brief, Albano's Market, that is facing the sidewalk?
I'm sorry.
It's page 9 of the
Record
appendix.
Page 9 of
It's
the
like the second to
appendix.
last page of the brief.
Yes.
And is the sidewalk right in front of there? Is that the public sidewalk?
That did not come out.
But that's the front door.
Yes, that's the front door set back, and so essentially this window is tucked in that side.
So the window is like on the, if you're looking at this photo, it's on the right?
I believe so, yes.
It's where the Coke signs are?
No, it's like right here, right in there.
Look how low that is.
See, because then if you look here, it's like, that's the Coke is right
So
here.
it's to the right of the door,
Yeah.
Yeah.
but it is on the sidewalk. I mean, you say alcove. I wasn't sure what you meant by alcove. You didn't mean it was an alley, did you?
No, actually, alcove was the term used during the testimony. The detective described it as essentially set back in a little alcove.
And when it was sitting there for the 13 hours, was the front door open and it was sitting on the side facing the door as we see it on page 10, or do we have any sense as to how it sat for the 13 hours?
I think it's set like this.
So with the door open? Is that-
No, the door's shut.
The door is shut?
Yeah, the store was closed.
Oh, so it's laying against the door and the door is closed,
And the door is like.
but it's sitting at an angle.
Yeah.
Right.
So it's leaning against the wall at an angle
That's how it appears,
and being
yes.
held up by the door, by the handle of the door.
Correct.
So it is protruding out onto the sidewalk.
Well, I think that is still in that alcove, what the detective described as an alcove.
Okay, okay, thank you.
Thank you.
All right.